We have one last amendment to be considered. I'd recognize the gentleman from California, Mr. Waxman, to offer an amendment.
I have an amendment. Mr. Chairman, I have an amendment at the desk.
The clerk will read the title of the amendment.
Amendment to H.R. 5 offered by Mr. Waxman of California.
The amendment will be considered as read. The staff will circulate the amendment, and the gentleman is recognized for 5 minutes in support of his amendment.
Mr. Chairman, this amendment is a very straightforward one, and I don't know that we need a lengthy debate on it, but I do want to explain it. Oftentimes there's a settlement of a lawsuit, and as a condition for settling the lawsuit, one of the parties, usually a hospital, pharmaceutical, medical device corporation, demands that individuals agree to secrecy provisions which prohibit them from disclosing any public health and safety hazard uncovered during the litigation. What my amendment would do is to say that when you have a issue that affects public health and safety, this kind of agreement cannot be reached. And it would be up to the judge to look at the case and decide whether it can be a sealed record. It would apply in healthcare lawsuits when a protective order is requested, and then the judge can decide in his discretion if a case is covered by this bill. The kind of situation I'm looking at and thinking of is when, let's say, a manufacturer of a product knows it's going to harm people. And he says, I know you've been harmed, and we're wrong. We'll pay you X number of dollars to settle the lawsuit, but I want you to agree that this will all be sealed. And by sealing it, that would mean that others wouldn't know, and the further harm to other people cannot be prevented. So that is what this amendment is all about. But Mr. Chairman, I'm so perplexed by the council's explanation of the bill on intentional acts that I want to go back to that issue in the remaining time that I have. The council is relying on page 21 to define a healthcare lawsuit. And it has to be an individual that provides services related to the diagnosis, prevention, or treatment of any disease or impairment, or the assessment or care of health of human beings. Now, the council said that if that person acts intentionally with malicious intent to injure, which is the next section on page 21, that it wouldn't be covered by this bill, although I don't know what would be covered as a, let me ask counsel, what would be covered by malicious intent to injure in section 13 on page 21?
Sir, what I said earlier is the limit on the types of cases that this bill applies to is defined by healthcare good or service, because that serves as the predicate, as the basis for healthcare laws.
So it would mean if you're providing a healthcare service and then you act with a malicious intent to injure, you would come under this law.
If you're performing a healthcare good or service, yes, sir.
Okay. Now I would submit my amendment, which is one of the two amendments I have pending, would say that if it's an intentional act, that shouldn't be covered by this because it puts limits on the damages, both the damages for compensatory and therefore also the limits on the punitive damages. I would ask counsel if the Bethesda dentist who sexually assaulted a teenage girl after he put her under laughing gas to fill her cavities, would that be considered under this bill or not under this bill?
The hypothetical that you've drawn, I believe that that act, in terms of the rape or what you've put forth, is not under the bill.
Not covered by the bill.
Yes, sir.
So therefore not covered by limits on punitives. How about a psychiatrist who persuades his patient to have sex with him in order to treat her emotional problems? Is that somebody providing a health care service?
May I interject?
Yes.
Because current ethics of a psychiatrist or a physician is that she or he should not enter into an intimate relationship with a patient.
Absolutely. And it may well also be against the law. But if this woman sues the psychiatrist, the counsel is saying that her lawsuit wouldn't be covered under this law. My amendment made that clear. I'm afraid it would be, because I can't understand what the next section is about malicious intent to injure. Let me give another. An OBGYN who performs an authorized abortion because he doesn't think the patient should have any more children. Violation of ethics, no question about it. It's in the course of performing a health service. And our counsel says that therefore the bill wouldn't apply. I would submit that I think it would apply, and that's why we ought to adopt this other amendment that excludes this, so there'd be no limits on punitive damages. Elderly resident in a nursing home locked in her room alone for days because the nursing home doesn't have enough staff. That's called a false imprisonment. That person ought not to have a limit on liability. The home ought not to have a limit on liability. It's hard to assess what the actual damages would be, or to say that the punitive damages ought to be limited. I talked about an infertility doctor who implants his own sperm into a patient who he's treating for infertility. Counsel said that that means that that person who is sued under those circumstances wouldn't be limited. It would be outside this act. I think we ought to make sure it's outside the act. I disagree with the counsel's conclusion. I'd submit that if the counsel advised me that interpretation of the law and then I forego suit, I'd sue him for malpractice. It would be an unintentional negligence on his part to advise me and the rest of us, as he is doing. But I think that he's wrong on his legal position. So, Mr. Chairman, I have two amendments. The second one, which I've just offered, is not to allow these secrecy agreements where the secrecy could keep public health information from getting out and preventing other diseases. And I've more than expired my time, and I thank you for your courtesy in allowing me to go on and on.
Patience.
And on. Patience.
Chair would recognize Dr. Gingrey to respond to the
Well,
second
Mr.
amendment.
Chairman, this is an amendment that we sort of had to quickly read, but I stand or sit in strong opposition to it. It places great restrictions, of course, on trial judges. The federal rules of civil procedure and comparable state procedure rules give trial judges the discretion to grant protective orders. This amendment greatly restricts that discretion for health care lawsuits, and in many instances, it would allow a trial judge to grant a protective order only after the judge makes specific findings. Failure to protect the confidentiality of settlement agreements would inhibit the settlement process. It would slow the payment of damages to victims of negligence. It would especially inhibit settlement of those marginal cases. And there are many of these, my colleagues, there are many of these, believe me, where a health care provider's guilt is in doubt, but both parties wish to resolve the case quickly and quietly for the sake of all involved. The constant threat that a court could find a public safety issue, even if none really existed, and thus break the confidentiality of the settlement, would deter the settlement from being made in the first place. As a practical matter, this amendment essentially compels each trial court to become a documents clearinghouse. Similar attempts to implement these restrictions on judges' discretion have been opposed by the Judicial Conference of the United States and the American Bar Association. As Judge Mark Kravitz, testifying on behalf of the Judicial Conference, informed the House Judiciary Committee with regards to limitations on protective orders, and I quote, requiring courts to review discovery information to make public health and safety determinations in every request for a protective order, no matter how irrelevant to public health or safety, will burden judges and further delay pretrial discovery. Beyond limiting judges' discretion, this amendment also increases the burden and the cost of litigation. If confidentiality and privacy are not protected, litigants will be forced to oppose any document request that an opposing party makes for information that may be sensitive or confidential. I oppose the adoption of this amendment, And with that, Mr. Chairman, I yield back the balance of my time.
Gentleman yields back. All time has expired. All those in favor of the amendment say aye. Aye. Those opposed say no. Noes have, roll call vote is asked for. A roll call vote will happen. Here is the order of, that concludes the amendments to this bill. We have 4 amendments that roll call votes have been ordered. The order will be the first Waxman amendment relating to intentional torts. The second rolled amendment will be the Towns amendment relating to medical malpractice. The third amendment will be the Markey amendment relating to the diversion of damage awards. The last amendment being this just debated amendment, the Waxman amendment on protective orders, at which point we will then go to final passage. So we have 5 recorded votes that are asked for. The first amendment, again, being the Waxman amendment on intentional torts, and the clerk will call the roll.
Mr. Barton? No. Mr. Barton, nay. Mr. Stearns? Mr. Whitfield? Mr. Shimkus? Mr. Shimkus, nay. Mr. Pitts? Mr. Pitts, nay. Mrs. Bono-Mack? Mrs. Bono-Mack, nay. Mr. Walden? Mr. Walden, nay. Mr. Terry? Mr. Terry, nay. Mr. Rogers? Mrs. Myrick? No. Mrs. Myrick, nay. Mr. Sullivan? Mr. Murphy? Mr. Murphy, nay. Mr. Burgess? Mrs. Blackburn? Mrs. Blackburn, nay. Mr. Bilbray? Mr. Bass? Mr. Bass, nay. Mr. Gingrey? Mr. Gingrey, nay. Mr. Scalise? Mr. Scalise, nay. Mr. Wada? Mr. Wada, nay. Mrs. McMorris-Rogers? Mrs. McMorris-Rogers, nay. Mr. Harper? Mr. Harper, nay. Mr. Lance? Mr. Lance, nay. Mr. Cassidy? Mr. Cassidy, nay. Mr. Guthrie? Mr. Guthrie, nay. Mr. Olson? Mr. Olson, nay. Mr. McKinley? Mr. McKinley, nay. Mr. Gardner? Mr. Gardner, nay. Mr. Pompeo? Mr. Pompeo, nay. Mr. Kinzinger? Mr. Kinzinger, nay. Mr. Griffith? Mr. Griffith, aye. Mr. Waxman? Mr. Waxman, aye. Mr. Dingle? Mr. Dingle, aye. Mr. Markey? Mr. Markey, aye. Mr. Towns? Mr. Pallone? Mr. Pallone, aye. Mr. Rush? Ms. Eshu? Mr. Engel? Mr. Engel, aye. Mr. Green? Mr. Green, aye. Ms. DeGette? Ms. DeGette, aye. Ms. Capps? Mr. Doyle? Ms. Schakowsky? Ms. Schakowsky, aye. Mr. Gonzalez? Mr. Inslee? Mr. Inslee, aye. Ms. Baldwin? Ms. Baldwin, aye. Mr. Ross? Mr. Ross, aye. Mr. Weiner? Mr. Weiner, aye. Mr. Matheson? Mr. Matheson, nay. Mr. Butterfield? Mr. Butterfield, aye. Mr. Barrow? Mr. Barrow, aye. Ms. Matsui? Ms. Christensen? Ms. Christensen, aye. Chairman Upton?
No.
Mr. Upton, nay.
Members not yet recorded. Mr. Stearns?
Mr. Stearns, nay.
Mr. Whitfield?
Mr. Whitfield, nay.
Mr. Bilbray?
Mr. Bilbray, nay.
Dr. Burgess?
Dr. Burgess, nay.
Mr. Towns?
Mr. Towns, aye.
Other members wishing to record their votes? Seeing none, the clerk will report the tally. Ms. Capps, Ms. Capps.
Mrs. Capps, aye. Mr. Upton?
Yes.
On that, there are 18 ayes and 29 nays.
18 ayes, 29 nays. The amendment is not agreed to. The next vote will be the town's amendment relating to PPACA provisions on medical malpractice, and the clerk will call the roll.
Mr. Barton. Mr. Barton, nay. Mr. Stearns. Mr. Stearns, nay. Mr. Whitfield. Mr. Whitfield, nay. Mr. Shimkus. Mr. Shimkus, nay. Mr. Pitts. Mr. Pitts, nay. Mrs. Bonomack. Mrs. Bonomack, nay. Mr. Walden. Mr. Walden, nay. Mr. Terry. Mr. Rogers. Mrs. Myrick. Mrs. Myrick, nay. Mr. Sullivan. Mr. Murphy. Mr. Murphy, nay. Mr. Burgess. Mr. Burgess, nay. Mrs. Blackburn. Mr. Bilbray. Mr. Bilbray, nay. Mr. Bass. Mr. Bass, nay. Mr. Gingrey. Mr. Gingrey, nay. Mr. Scalise. Mr. Scalise, nay. Mr. Wada. Mr. Wada, nay. Mrs. McMorris Rogers. Mrs. McMorris Rogers, nay. Mr. Harper. Mr. Harper, nay. Mr. Lance. Mr. Lance, nay. Mr. Cassidy. Mr. Cassidy, nay. Mr. Guthrie. Mr. Guthrie, nay. Mr. Olson. Mr. Olson, nay. Mr. McKinley. Mr. McKinley, nay. Mr. Gardner. Mr. Gardner, nay. Mr. Pompeo. Mr. Pompeo, nay. Mr. Kinzinger. Mr. Kinzinger, nay. Mr. Griffith. Mr. Griffith, nay. Mr. Waxman. Mr. Dingle. Mr. Dingle, aye. Mr. Markey. Mr. Markey, aye. Mr. Towns. Mr. Towns, aye. Mr. Pallone. Mr. Pallone, aye. Mr. Rush. Ms. Eshu. Mr. Engel. Mr. Engel, aye. Mr. Green. Mr. Green, aye. Ms. DeGette. Ms. DeGette, aye. Mrs. Capps. Mrs. Capps, aye. Mr. Doyle. Ms. Schakowsky. Ms. Schakowsky, aye. Mr. Gonzalez. Mr. Inslee. Mr. Inslee, aye. Ms. Baldwin. Ms. Baldwin, aye. Mr. Ross. Mr. Ross, aye. Mr. Weiner. Mr. Weiner, aye. Mr. Matheson. Mr. Matheson, nay. Mr. Butterfield. Mr. Butterfield, aye. Mr. Barrow. Mr. Barrow, aye. Ms. Matsui. Ms. Christensen. Ms. Christensen, aye. Mr. Upton.
No.
Mr. Upton, nay.
Other members wishing to cast a vote? Mr. Rush. Mr. Rush
Mr.
votes
Rush,
aye.
aye.
Mr. Waxman votes aye.
Mr. Waxman, aye.
Mr. Terry.
Mr. Terry, nay.
Mr. Sullivan.
Mr. Sullivan, nay.
Mrs. Blackburn.
She is not recorded. Mrs. Blackburn? Oh, you're not recorded, I'm sorry. Nay.
Votes no.
Mrs. Blackburn, nay.
Other members wishing to cast a vote? Seeing no more, the clerk will report the tally.
Mr. Chairman, on that, there are 18 ayes, 31 nays.
18 ayes, 31 nays. The amendment is not agreed to. The next vote will be the Markey Amendment relating to diversion of damage awards, and the clerk will call the roll.
Mr. Barton. Mr. Barton, nay. Mr. Stearns. Mr. Stearns, nay. Mr. Whitfield. Mr. Whitfield, nay. Mr. Shimkus. Mr. Shimkus, nay. Mr. Pitts. Mr. Pitts, nay. Mrs. Bonomack. Mrs. Bonomack, nay. Mr. Walden. Mr. Walden, nay. Mr. Terry. No. Mr. Terry, nay. Mr. Rogers. Mrs. Myrick. No. Mrs. Myrick, nay. Mr. Sullivan. Mr. Sullivan, nay. Mr. Murphy. Mr. Murphy, nay. Mr. Burgess. Mr. Burgess, nay. Mrs. Blackburn. Mrs. Blackburn, nay. Mr. Bilbray. Mr. Bilbray, nay. Mr. Bass. Mr. Bass, nay. Mr. Gingrey. Mr. Gingrey, nay. Mr. Scalise. Mr. Scalise, nay. Mr. Wada. Mr. Wada, nay. Mrs. McMorris Rogers. Mrs. McMorris Rogers, nay. Mr. Harper. Mr. Harper, nay. Mr. Lance. Mr. Lance, nay. Mr. Cassidy. Mr. Cassidy, nay. Mr. Guthrie. Mr. Guthrie, nay. Mr. Olson. Mr. Olson, nay. Mr. McKinley. Mr. McKinley, nay. Mr. Gardner. Mr. Gardner, nay. Mr. Pompeo. Mr. Pompeo, nay. Mr. Kinzinger. Mr. Kinzinger, nay. Mr. Griffith. Mr. Griffith, nay. Mr. Waxman.
Aye.
Mr. Waxman, aye. Mr. Dingle. Mr. Dingle, aye. Mr. Markey. Mr. Markey, aye. Mr. Towns. Mr. Towns, aye. Mr. Pallone. Mr. Pallone, aye. Mr. Rush. Mr. Rush, aye. Mrs. Eshu. Mr. Engel. Mr. Engel, aye. Mr. Green. Mr. Green, aye. Ms. DeGette. Ms. DeGette, aye. Mrs. Capps. Mrs. Capps, aye. Mr. Doyle. Ms. Schakowsky. Ms. Schakowsky, aye. Mr. Gonzalez. Mr. Inslee. Mr. Inslee, aye. Ms. Baldwin. Ms. Baldwin, aye. Mr. Ross. Mr. Ross, aye. Mr. Weiner. Mr. Weiner, aye. Mr. Matheson. Mr. Matheson, nay. Mr. Butterfield. Mr. Butterfield, aye. Mr. Barrow. Mr. Barrow, aye. Ms. Matsui. Ms. Christensen. Ms. Christensen, aye. Mr. Upton.
Votes no. Other members wishing to cast a vote? Seeing none, the clerk will report the tally.
Mr. Chairman, on that, there were 18 ayes and 31 nays.
18 ayes, 31 nays. The amendment is not agreed to. Now, the last amendment is the Waxman Amendment regarding protective orders, and the clerk will call the roll.
Mr. Barton.
What is this?
Mr. Barton, nay. Mr. Stearns. Mr. Stearns, nay. Mr. Whitfield. Mr. Whitfield, nay. Mr. Shimkus. Mr. Shimkus, nay. Mr. Pitts. Mr. Pitts, nay. Mrs. Bono-Mack. Mrs. Bono-Mack, nay. Mr. Walden. Mr. Walden, nay. Mr. Terry.
No.
Mr. Terry, nay. Mr. Rogers. Mrs. Myrick. Mrs. Myrick. Mrs. Myrick, nay. Mr. Sullivan. Mr. Sullivan, aye. Mr. Murphy. Mr. Murphy, nay. Mr. Burgess. Mr. Burgess, nay. Mrs. Blackburn. Mrs. Blackburn, nay. Mr. Bilbray. Mr. Bilbray, nay. Mr. Bass. Mr. Bass, nay. Mr. Gingrey. Mr. Gingrey, nay. Mr. Scalise. Mr. Scalise, nay. Mr. Latta. Mr. Latta, nay. Mrs. McMorris Rogers. Mrs. McMorris Rogers, nay. Mr. Harper. Mr. Harper, nay. Mr. Lance. Mr. Lance, nay. Nay. Mr. Cassidy. Mr. Cassidy, nay. Mr. Guthrie. Mr. Guthrie, nay. Mr. Olson. Mr. Olson, nay. Mr. McKinley. Mr. McKinley, nay. Mr. Gardner. Mr. Gardner, nay. Mr. Pompeo. Mr. Pompeo, nay. Mr. Kinzinger. Mr. Kinzinger, nay. Mr. Griffith. Mr. Griffith, nay. Mr. Waxman. Mr. Waxman, aye. Mr. Dingle. Mr. Dingle, aye. Mr. Markey. Mr. Markey, aye. Mr. Towns. Mr. Towns, aye. Mr. Pallone. Mr. Pallone, aye. Mr. Rush. Mr. Rush, aye. Ms. Eshu. Mr. Engel. Mr. Engel, aye. Mr. Green. Mr. Green, aye. Ms. DeGette. Ms. DeGette, aye. Mrs. Capps. Mrs. Capps, aye. Mr. Doyle. Ms. Schakowsky. Ms. Schakowsky, aye. Mr. Gonzalez. Mr. Inslee. Mr. Inslee, aye. Ms. Baldwin. Ms. Baldwin, aye. Mr. Ross. Mr. Ross, aye. Mr. Weiner. Mr. Weiner, aye. Mr. Matheson. Mr. Matheson, nay. Mr. Butterfield. Mr. Butterfield, aye. Mr. Barrow. Mr. Barrow, aye. Ms. Matsui. Ms. Christensen. Ms. Christensen, aye. Mr. Upton.
Votes no. How is Mr. Sullivan recorded?
The gentleman is recorded aye. Mr. Sullivan, off aye, on nay.
Mr. Rogers?
Mr. Rogers is not recorded. Mr. Rogers, nay.
Are there other members wishing to cast a vote on this last amendment? If not, the clerk will report the tally.
Did he keep saying aye? Did I misrecord him? Yeah. Wow.
You got it right.
32. Oh, yeah. Mr. Chairman, on that, 18 aye, 32 nay.
18 aye, 32 nay. The amendment is not agreed to. At this point, the question now occurs on favorably reporting the bill, and the clerk will call the roll.
As amended. Mr. Barton. Mr. Barton, aye. Mr. Stearns. Mr. Stearns, aye. Mr. Whitfield. Mr. Whitfield, aye. Mr. Shimkus. Mr. Shimkus, aye. Mr. Pitts. Mr. Pitts, aye. Mrs. Bono-Mack. Mrs. Bono-Mack, aye. Mr. Walden. Mr. Walden, aye. Mr. Terry. Mr. Terry, nay. Mr. Rogers. Where is he? Mr. Rogers, aye. Mrs. Myrick. Mrs. Myrick, aye. Mr. Sullivan. Mr. Sullivan, aye. Mr. Murphy. Mr. Murphy, aye. Mr. Burgess. Mr. Burgess, aye. Mrs. Blackburn. Mrs. Blackburn, aye. Mr. Bilbray. Mr. Bilbray, aye. Mr. Bass. Mr. Bass, aye. Mr. Gingrey. Mr. Gingrey, aye. Mr. Scalise. Mr. Scalise, aye. Mr. Latta. Mr. Latta, aye. Mrs. McMorris Rogers. Mrs. McMorris Rogers, aye. Mr. Harper. Mr. Harper, aye. Mr. Lance. Mr. Lance, aye. Mr. Cassidy. Mr. Cassidy, aye. Mr. Guthrie. Mr. Guthrie, aye. Mr. Olson. Mr. Olson, aye. Mr. McKinley. Mr. McKinley, aye. Mr. Gardner. Mr. Gardner, aye. Mr. Pompeo. Mr. Pompeo, aye. Mr. Kinzinger. Mr. Kinzinger, aye. Mr. Griffith. Mr. Griffith, nay. Mr. Waxman. Mr. Waxman, nay. Mr. Dingle. Mr. Dingle, nay. Mr. Markey. Mr. Towns. Oh. Mr. Markey. Mr. Markey, nay. Mr. Towns. Mr. Towns, nay. Mr. Pallone. Mr. Pallone, nay. Mr. Rush. Mr. Rush, nay. Ms. Eshu. Mr. Engel. Mr. Engel, nay. Mr. Green. Mr. Green, nay. Ms. DeGette. Ms. DeGette, nay. Mrs. Capps. Mrs. Capps, nay. Mr. Doyle. Ms. Schakowsky. Ms. Schakowsky, nay. Mr. Gonzalez. Mr. Inslee. Mr. Inslee, nay. Ms. Baldwin. Ms. Baldwin, nay. Mr. Ross. Mr. Ross, nay. Mr. Weiner. Gentleman is not recorded. Nay. Mr. Weiner, nay. Mr. Matheson. Mr. Matheson, aye. Mr. Butterfield. Mr. Butterfield, nay. Mr. Barrow. Mr. Barrow, nay. Ms. Matsui. Ms. Christensen. No. Ms. Christensen, no. Mr. Upton. Mr. Upton, aye.
Are there other members wishing to cast a vote? Seeing none, the clerk will report the tally.
I've got my request on.
Okay.
Mr. Chairman, on that, there are 30 ayes and 20 nays.
30 ayes and 20 nays. The ayes have it, and the bill is favorably reported. Without objection, staff is authorized to make technical and conforming changes to the bill approved by the committee today. Hearing no objection, so ordered, I would recognize the ranking member, Mr. Waxman.
Mr. Chairman, pursuant to House Rule 11, Clause 2, either 1 or L, I'm notifying you of the intent of minority members to submit views regarding H.R. 5 and request the requisite number of days for doing so.
Without objection, so ordered, no problem. The committee now stands adjourned.